the single thing without considering that the fact that the modification application is pending, the order was passed to remove the seal and the cost of the 20,000 was involved. During the pendency of this appeal, the final order has been passed with respect to the modification part, and the order has again been against the Lord and directed to remove the seal. Since the Honorable High Court, the single judge has directed to remove the seal and cost has been imposed. Therefore, my recall application was also rejected, which is also part of this LPA.
So tell us, it's a building. The subject matter of the proceedings or litigation is a building. The building is something which is not an imaginary thing, it's actually existing. And all this narration of facts which are
the construction law is
these are all the subject matter of the proceedings. What is the purpose of the subject matter? The appellant or the petitioner makes out a prima facie case balance. One view has been taken by the learned tribunal. Learned writ court affirms that view, does not find any perversity on that score. Now in appeal, before intra-court appeal before us, how do you say that the order of the learned judge is perverse, requiring interference? If the building exists in the first order of demolition and was passed in 2007 and then again another proceeding for demolition, we do not know why you initiated another proceeding when the writ petition was dismissed. But you initiated another proceeding before intra-court appeal before us. How do you say that the order of the learned is perverse, requiring interference? If the building exists in the first order of demolition and was passed in 2007 and then again another proceeding for demolition, we do not know why you initiated another proceeding when the writ petition was dismissed. But you initiated another proceeding before intra-court appeal before us. How do you say that the order of the learned is perverse, requiring interference? If the building exists in the first order of demolition, whether there was an application for revised sanction plan or not, where there was any difference in the date on which the revised sanction plan was submitted of 2007 or 2018, as perhaps you have tried to show before the learned single judge. If there were errors in the order of the learned single judge on the first occasion when the writ petition was dismissed, you never sought a review of that order. It was not required. You initiated a fresh proceeding. Now that proceeding is on its journey up to different ladder. And the first appellate court has taken a view of the entire thing that because of these reasons, the ceiling needs to be open till the time the appeal is decided. The appeal is time bound to be decided, maybe few months. Therefore, if the subject matter of the property is being preserved by the main adjudicating body tribunal because of finding some prima facie case and balance of convenience and obviously irreparable loss, because if the building goes, then it's almost equal to irreparable loss. In that case, you have not declared the building as condemned. So therefore, you cannot make that argument. If your engineers had declared under the relevant provisions of the RMC Act that the building. So therefore, why should the latest patent court take any other view of the matter when the learned single judge has considered all your arguments and held that yes, it's an interim order, and why interim order is passed? वो judgment नहीं मंगा है क्या? ये जो है no, I have given a citation. आप जल्दी मंगाया करिए भाई. Why an interim order is passed? To protect the subject matter. Otherwise, the appeal would become infructuous.
But I pose a question to myself, whether I can open a premises which does not possess a building plan.
So this the appellate authority is in season of.
There is an order that is building plan. I have the proper particular order.
We are going the case before an appellate court on the same grounds in which the writ court's order doesn't suffice.
It would be appropriate instead of removing the scheme if the appeal is being heard. But one week the appeal खत्म हो जाएगी then whatever you are doing,
so therefore wait for the outcome of the appeal. Why are you so?
Instead of removing the scheme, let the appeal be disposed of.
No, it is not the way in which one party to a litigation feels that this should be the way. In fact, that is what the learned single judge has frowned upon, very seriously frowned upon.
Yes.
Interim order of any body, adjudicatory body, that has to be respected. You think that we will open it after the appeal is decided. Why? The learned tribunal thinks that no, it should be opened right now.
But the tribunal has not considered this regard the appeal was dismissed. This fact has not been considered. So while the unjudicial case is concerned, that has not been adjudicated.
We are not able to find any such. In fact, perversity is a word which need not be used. Why should we take a substitute view of the matter?
Yes, I go on. But this one thing was that since the privacy case has to be made out, I have been a privacy case and do not possess any building plan. But therefore, moving a COD.
Perhaps you seem to be more hurt by the cost that has been incurred.
No. Look, I am not so hard with the cost, I will call it the cost. And only concerned about the National Corporation is taking a steps to improve in the society.
You don't talk about.
Don't
talk about how. There are many skeletons in the cupboard, so don't talk about all that. How good the face of the city looks. How many building plans to be finished, executed within a time frame. Any building is to be constructed within a time frame as stipulated in the building plan. If in a PIL you are asked to show that how many building plans you have given that occupancy certificate, where would you stand? None of the buildings are complete. No plasters. On the main road, without plaster building is standing. Where is your building plan? Where is your junior engineer? Where is your assistant engineer who is supposed to inspect and then cancel? All building materials lying on the road. There is a condition that you cannot keep the building material on road or you will have to pay a particular fee for every day. So all these things are there. No? The face of the city can itself say for itself as to how good. But why should we observe on that? We are confining to this case. So maybe your intentions might be good, but there is nothing wrong in the order for us to interfere in the courts. It is not an illegality because there is an order of an appellate body which stands affirmed by the writ court. The appellate court will consider whether your contentions are true or their contentions are true. So therefore, so long it doesn't say that, whatever you are saying is half side of the story.
So I am not modification partner and the modification there I am not drawing about every document law that in the modification application or order was passed on 15 February and that order also does not contain anything from my side. Only because the single judge has dismissed the application with imposing a cost, my modification application also possibly rejected. This is the whole narration that I brought into the and so the basic purpose of writing modification was that does not possess a building plan that has not been considered. This was the only basic intention of writing modification. And was not available for me when the original order was passed. So the record was with the authority. It would not have the access to it.
We are not sitting as the appellate tribunal of the RMC here. So all this narration of facts, we allowed you to address because we thought that this is necessary for you to make out a point. But we do not think that a good point has been made out for interference. The writ court has taken into account all your arguments.
Yes, and they could have taken all my argument, but this particular fact law with regard to the modification law which has been which we have referred here. The modification application which we have referred because the tribunal again has not considered entire and only of the reason law.
That order is a separate subject matter.
That I have brought in the value of my separate.
Can't see here as a first court. And why should we?
Also can take of this order
No.
because this the modification of because the order are under legal judge. The tribunal also passed an order pursuing section number A regard but did not pursue thereafter regard. Sir, suppose that building does not possess
Don't repeat your answer.
Sorry. But I was only making my humble submission with lots of cases. If there is no hard a time would be framed lot or 1 week or a day lot tomorrow or day after tomorrow.
When is the next date for hearing?
Tomorrow, yesterday was the date fixed lot and thereafter lot I do not know what's the next date fixed lot. That's the name.
Let us open the seal because the running that we have employed about 25-30 people. They are not job. They just simply can't say, let the appeal be heard until then the building premises be sealed. And that too, they are selectively targeting. They have only sealed second, third, fourth, fifth floor of the building in which I am running the hotel. And the remaining portion where they say that the basement is being used as shop, they are not sealed. That's selectively targeting.
So far as we got
And secondly, what my friend is saying that there is no building there. That order cancelling the building plan was on basis of title distributing the portions. That order was modified. It's part of the record of 50 also, page 63. That order should modified. The previous landowners and the purchase and the subsequent purchase. The previous landowners were asked to remove certain deviations. How my friend is saying that this is a
ability. Why are you questioning the appeal thereafter?
This is record. And second, most importantly, the order of demolition and imposing cost on me has been passed in violation of Section 436 of the Municipal Act. I was not even heard. Case was initiated against my hotel. I was not even noticed. Previous landowners were noticed. They were heard and the order has been passed. But I have to see
when did you purchase the property?
2007.
And when this order has been passed, demolition?
2029. Demolition order was Section 6 page 73 that is passed from 21.
The demolition order was passed on 38 2007 and thereafter
This order which is not subject matter to the
6/5/2007 original order was passed. Thereafter appeal was upon order 38/2007 and writ petition was dismissed in Lord in year 2018.
The last of the demolition order pursuant to the meeting of 2019.
And in that you were not noticed.
I was not noticed. I can say that.
In the writ petition, whether you had got substituted. In the writ petition which was decided in 2018, where you got substituted.
Because I am only owner of a portion of the building, not entire.
So the entire building has not been sealed.
No, not entire building, only my portion. What the commissioner has released.
There are various questions involved and
These are subject matter. These issues should be dealt by the learned
Meeting regard is a long process regard. Step-by-step is required because the time cutting needs to happen regard. So हम लोग ने एक slow to see cutting to succeed किया.
once you succeed in appeal, take all steps.
Lord, there is a record petition they will stop regard.
No, that is incorrect. That is incorrect.
No.
That is incorrect.
Was there any stay in that 2007 writ petition?
It is actually incorrect statement. What my friend is, let me just narrate what has happened after I purchased. The writ petition was disposed of, the earlier amount of writ petition was disposed of. My friend had submitted the revised plan. The actual revised plan was submitted in the year 2007 for RTA. RTA and RLC both were parties in the 2007 writ petition. It was disposed of in their presence. In RLC again, they resubmitted the application for revision of the building plan. Thereafter, when the commissioner issues notice to the previous owners, it does not issue notice to me and starts a UC case. In that, order of demolition has been passed and imposing another 5 lakh cost on me without even paying. This order is subject matter of appeal for the honorable the tribunal. These are meanwhile.
Imposing cost upon you by the name of this petitioner.
Yes, sir. Can we take 17 or more?
Read it out. Page.
Page 73.
Yes. Yes.
Unaffected Nirmal Box in the Sherwala East Hotel Center Point Neighbor Branch. So the proceeding is initiated against me. And my lord, this is the entire order. My lord, not a single case, my lord, the commissioner has even recorded that notice was issued to them. In fact, my lord, in the next page, you find
Yes.
that third line from the top. University Bound पर आवेदन नहीं मिले तो भीड़ वास्तव में निर्माण सहयोगी समिति के अध्यक्ष श्री संजय जायसवाल representative राजेश सिंह राजेश मिश्रा और सर्विसेज कर्मचारी द्वारा कथित रूप से समर्पित अनुसार आवेदन आउटपुट सर्टिफिकेट में उपलब्ध कराने का निर्देश दिया गया। I was never noticed. Because my specific pleading in the written petition not controverted.
Your vendor was this. This Sahyog Samiti was the vendor.
No, Sahyog Samiti was the builder.
Okay. And who was your vendor?
My vendor was the owner of the property. I had those my safety to my identification. Vijay Prasad, Bharti Devi, Mamta Rana, Meera Prasad, Vijay Sharma, Sanjay Datta. They were the owners of the property.
So they were noticed, you were not noticed.
I was not.
And the UC case which you are fighting is in respect of only that part of the property that you have purchased or the whole of it?
No, I am only concerned with my.
No, whether the demolition is to be intended for the entire building.
The entire building is required to be demolished. The deviation portion. No.
And in that case, if it is to be demolished, then the UC case is also against the rest part, owner of the rest part.
बेसमेंट में निर्मित दुकान को अपसारित करें, ग्राउंड फ्लोर में निर्मित दुकानों को अपसारित करें, स्वीकृत नक्शे में प्रथम तर्जे से चतुर्थ तर्जे तक आवासीय प्लॉट की स्वीकृति दी गई थी, परंतु निर्माणकर्ता द्वारा अनाधिकृत रूप से दुकान का निर्माण किया गया था। प्रथम तर्जे से चौथे तर्जे तक किए गए अवैध रूप से निर्मित दुकानों को अपसारित करें। भवन के पांचवें तर्जे का निर्माण अवैध रूप से किया गया, अथवा पांचवें तर्जे को किए गए निर्माण सभी को अपसारित करें। entire building is required to be demolished.
So therefore, we are asking that whether the owner of the remaining part has also been proceeded against.
No, they have not referred any.
No, we are asking you. You know about the entire proceeding against that building. Part of it is owned by him.
Yes.
Rest part, which is owned by some ex-person, have you also proceeded to demolish that part?
We have proceeded for sealing purposes.
No, they have not yet.
No, we are sealing would only follow an order of demolition, na? So whether have you proceeded against the rest part of that?
We start with the fifth floor. Fifth floor, third floor, like this.
On the one hand, you say the entire building has to be demolished. Then the UC case is only against owner who has only 2-3 floors from. That apart, you have to demolish the building, na? So again, he says that he has not been noticed. Now, rest part also, they will say they have not been noticed. and you want the entire thing to be going around in circle instead of the actual execution being carried out.
Suppose they also transfer later on, they now a new vendor cannot say that I was not put in notice. How municipal corporation would be aware that the property has been transferred?
You have started the proceeding against his name,
Now we are telling have got the order passed by the single.
and you have a team who carries on inspection. They are bound to produce documents. If you notice them, in fact, any adjudicatory body can ask for documents and proof.
Kindly have not kindly I put the notice. What they responding? Kindly have not. Page 17 or kindly have not. So the order passed by the single cell, and thereafter you have to notice. Page 17 or kindly have not.
70.
Yes. Number 6. Accordingly, the writ petition is dismissed. However, the writ respondent authority shall consider the revised plan of the petition according to the law without being prejudiced to order of the decision of the respondent. Now, thereafter, Lord, I inquired in the entire office and we have given us 71 columns. Lord, because there are since Lord, the petitioners who were party were delayed in the writ petition Lord, in the UC case, we put the notice to all these persons. We will not say that Lord, the property is not transferred.
No, that excuse. That excuse you will not have.
Now
No?
that page 72, they come up with the response. They did not respond that the property has been transferred. And when we started initiating UC case, then they say the property has been transferred.
You see, their property is purchased under a registered deed. Registry is a notice to the people at large.
Yes.
Then, so can you say legally that you were not aware of the transfer?
I put a question. Suppose the property is
No, we don't find any substance in this challenge.
I suggest one thing. The next date is 15 3
No, we don't.
15 3 the next date
No, why should we? There are 50 to 100 petitions or more than that pending before the appellate tribunal. We do not know how it is running its own docket. No, we say that there might be hundreds of petitions pending. How the tribunal operates its own docket, it's for it to decide. I have, say, in our roster, there are 500 cases. So we decide how our cases are to be listed. No? One case out of turn, why should we? So let them take a date and you pursue the matter there. And yes. So ultimately, if you succeed, they lose, the building has to go. The building may survive 1 year or 6 months or few months more. You cannot foreclose. You don't make those childish arguments. You cannot preclude a party from pursuing it. Even an accused who is pursuing a remedy for revision, 482, anything, cannot say that it is prevented from doing so because Article 21 requires expeditious disposal of the trial. Not worth interference. You carry out the interim order. So they are in contempt. Interim relief is granted in aid of final relief. The object is to ensure protection of the property being the subject matter, so that the proceedings do not become infructuous. And the three principles are good prima facie case, balance of convenience, and irreparable injury. Unless interim applications are decided expeditiously, irreparable injury or prejudice may be caused to the party seeking interim. We have heard. We will increase the cost now. Yes, take down. We have heard learned counsel for the appellant Ranchi Municipal Corporation, the writ petitioner slash respondent, and the Ranchi Regional Development Authority, who is only a pro forma respondent. The appeal appellant is aggrieved by the judgment dated 31st January 2022, passed by the learned writ court, by which the writ petition preferred by the Ranchi Municipal Corporation has been dismissed with cost as being frivolous in nature. Intended to save the RMC from deliberate non-compliance of the interim order passed by the learned tribunal. Stop. Learned writ court has allowed the writ petition preferred by writ petitioner मत लिखिएगा writ petitioner both थे ये लिखिए respondent number 1 यहाँ ऊपर में लिखे थे ना writ petitioner और respondent number 1. Learned writ court has however allowed writ petition civil number 6 of 2022 instituted by the respondent number 1 with a direction to the Ranchi Municipal Corporation to comply the interim order dated 16 December 2021 passed by the Appellate Tribunal RRDA Ranchi in miscellaneous appeal number 36 of 2021, which shall be and indicated that it shall be effective till the same is either modified by the Appellate Tribunal or disposal of the said miscellaneous appeal. Stop. Respondent number 1 approached the writ court for a direction upon the respondent RMC / appellant hearing to forthwith remove the seal of its hotel Center Point in view of the interim order dated 16 December 21 passed in miscellaneous appeal number 36 of 2021, directing the RMC to remove the seal from the said hotel premises. Ranchi Municipal Corporation appellant herein preferred WPC number 157 of 2022 for quashing the order dated 16 December 21 passed by the learned Appellate Tribunal Ranchi in the said miscellaneous appeal. Stop. The miscellaneous appeal number 36 of 2021 arises out of an order passed in UC case number 6 of 2021 dated 27th December. What is the date of that? 8th September 2021, whereunder The Municipal Commissioner, Ranchi Municipal Commission Corporation, ordered for demolition of fifth floor of the said building and also imposed a penalty of rupees 5 lakhs on the firm. Stop. There was a previous round of proceedings initiated by the Ranchi Regional Development Authority against the vendor of the present petitioner, against the vendor of the respondent number 1, writ petitioner. Being BC case number 698 of 2007. No, sorry, UC case number 135 of 2001. Wherein the owners of the property were directed to remove the unauthorized construction within 30 days from the date of order. Stop. The miscellaneous appeal number 19 of 2007, referred by the aggrieved owner, namely Srimati Munni Devi, was dismissed by the Appellate Tribunal RRDA by the order dated 30th August 2007. Stop. Thereafter, the vendor of the firm preferred a writ petition. Vendor of the respondent number 1 preferred a writ petition being WPC number 5512 of 2007. Stop. The writ petition was dismissed by order dated 23rd October 2018. Holding as under. Para 3, 4, 5 and 6. Page 69 and 70. In the meantime, the jurisdiction of the RRDA was transferred to the Ranchi Municipal Corporation. In the meantime, during pendency of the previous writ petition, the jurisdiction for sanctioning building plans was transferred to the Ranchi Municipal Corporation under the Jharkhand Municipal Act 2011. Stop. On the basis of correspondence undertaken by the Deputy Town Commissioner, Ranchi Municipal Corporation, via letter number 1590 dated 27 December 2021 with the Secretary RRDA, it came to know that there was no revised plan for BC case number 698 of 2007 was sanctioned by it at the relevant point of time. Stop. However, on being aggrieved by the order dated 8 September 2021 passed in UC case number 6 of 2021, directing demolition of the fifth floor Mr. Roy, fifth floor.
The earlier round, the earlier was being right?
No, the latest 8th September order.
8th September order is, let's say, remove the alleged deviation. The alleged deviation is page 63. एक्सपर्ट ने हमारे दुकानों को अवसारित करें, ग्राउंड फ्लोर में निर्मित दुकानों को अवसारित करें, स्वीकृत नक्शों में प्रथम तंत्र से चतुर्थ तले तक आवासीय फ्लैट की स्वीकृति की यदि परंतु निर्माण क्षेत्र द्वारा बनाए गए दूसरे दुकान का निर्माण किया गया है, मतलब प्रथम तले से चौथे तले तक किए गए अवैध निर्माण दुकानों को अवसारित करें, भवन फ्लैट में पांचवें तले का निर्माण अवैध रूप से किया गया है, मतलब पांचवें तले को सभी निर्माण को सरल करें।
क्या लिख रहे थे? Directing Absarif means what? Directing demolition of the basement of the shop, the ground floor.
But this is not the previous been discussed, but this instruction is not permitted to comply the order.
Very well, we have not yet finally passed the order. So then we will first part में जो challenge का था उसका रहने दीजिए, रिट कोर्ट के ऑर्डर का. उसके बाद कहिए learned counsel for the appellant after some arguments on instructions seeks permission to withdraw this appeal and withdraw the appeal and comply the order of the learned writ court. Stop. Appearance you both of you give. In view of the prayer made on behalf of the appellant, the instant appeal is dismissed as withdrawn. That will come day after tomorrow. We have already passed an order for removing the defect. Pending IAs are closed.
Item number 24, WPT 0215 of 2022, which are particular on behalf of the policeman. Rajiv Singh, Navneet Kumar from Police.
जरा उन लोग को बुलाइए तो. Yes. This is a case where the petitioner claims that instead of depositing the cash in the electronic cash ledger of one GSTIN, it has been deposited in the other one, and a proceeding has been initiated and concluded till appellate stage on his application for refund. Rejected. So you can file your counter affidavit. 4 weeks. Mr. Amit Kumar. Huh? Obviously. 4 weeks time is allowed to learn, as paid for 4 weeks time is allowed to learn counsel for the respondent CGST to file counter affidavit. 1 week thereafter to the petitioner to file reply if so advised. The matter be listed after 5 weeks. 2 weeks time to file reply, the matter be listed after 6 weeks.
But the order passed by the earlier single judge.
However, it is made clear that the this court has not gone into the merits of the challenge. Stop. The learned tribunal, it is open for the learned tribunal to decide the pending appeal on its own merits without being influenced by any observations made by this court.
One more observation. You have to speak about the appeal, but time may be, but experience is more, experience, what experience is going to be.
No, we do not know. We do not know about its pending. Yes.
Item 25, WPT number 500, office financial entity. Mr. Kumar Vaibhav for the release.
So, fan तेज करवाइए. So counter affidavit and rejoinder have been filed through mail, e-filing or email filing rather. Email filing. E-filing will only happen when the writ petition is filed through e-filing. Only thing. So as per you, one Subhash Kumar Modi responded to your queries and said that I have never given any money and 55 lakhs in cash to the petitioner.
That was the reason to believe my assessment has been reviewed. Therefore, the department is saying that this is not a true and full disclosure. And the 147 says there was not true and full disclosure. That was not.
Yes, so what do you have to say?
I will make a very brief summation first. The reasons as the whole and full of any reassessment proceedings. The legality of the reassessment proceedings is to be assessed based on the reasons alone. No counter affidavit can justify the reasons. My first thing of submission is that the reasons are not sufficient yet, and the reasons do not fulfill the requirement under 147 first provide. That is my first.
In GK guidelines, it has been stated reasons may be good or bad. If there is reasons.
What I mean to submit is, it is not a case of regular assessment. It is a case of scrutiny assessment. On the same point, when scrutiny was held, and no other document is required to be looked into apart from what has been stated in the reasons. And surprisingly, even if I look at the counter affidavit, during the pendency of the scrutiny proceeding, the investigation will also initiated some inquiry. Because it is not that it was completely subsequent. And just to by way of abundant caution, I have also filed an IA. My SSC is confident that Subhash Modi will confirm the transaction because he has disclosed it in some proceedings.
In the fresh proceedings now which has been initiated, why can't all these things be verified?
Subhash Modi will go and tell before the assessing officer.
But we just simply indicate that IWAS is not entering into the merits of
the
reasons, and I am at liberty to raise everything before the assessing. So I have also raised the point in my rejoinder. We are referring to one letter which was never served on me. It is only from this counter affidavit I am getting to know.
On one hand, we are not entering into the letter to the customer. Shall decide the case.
To the point of view of the department, somebody has to be held accountable for the 55 lakhs of cash. They are interplaying between themselves. So If Subhash Modi has denied, then if he is saying that he'll accept, then let him go and do report the assessing officer.
If I had to, if I had to make it a black money, I would have never deposited it in the bank account. I am depositing it in my bank account, Lord. I will not deposit an amount which I have to, Lord, conceal.
And that is what is surprising also.
Because I have been instructed, Lord, so it is not on record. Last Modi is a person who is above 85 years of age. He was harrowed by the revenue with numerous notices. That's why getting irritated, he said, I am not done anything, I am not doing anything. That is the true fact of the matter.
In fact, Mr. Modi has confirmed that these are not my signatures. He has said that my signatures have been forged.
I made a specific statement in my IM notes. Yes, disclosed the balance sheet.
If that is so, then the petitioner must have been a fool to deposit 55 lakhs on the name of a fictitious person.
It is very easy for the SSCs to go auditors. What they do is they bring all these documents, and when the department doesn't cross check, the department believes it, they get through them. Therefore, the government is time again bringing restrictions of cash transactions.
At what
It is very easy. They will get a.
No, it has to be 269 SS. So, Usab.
That time that restriction was not there because prior to demonetization, you will not define.
No.
Might not only see the reason.
269 SS. So that was there also.
Yeah, 269 SS was there. The 2 lakh limit, 2 lakh limit came under 269 ST after the demonetization.
2 lakhs.
My only point is the reasons, and itself, there are judgments which say, that it is mere receipt of information from investigation based, because it is borrowed satisfaction. If my lord is impressed upon my argument on the reasons itself, then I will have a case, if my lord is not convinced, I will not bother my lords to just enter into the merits of the case, because that will prejudice the SSC in case of in the assessment proceedings. If my lord is convinced, I will try to demonstrate how the reasons itself will fall the case of error. Because in reasons they have not mentioned anything specifically, and there are 2 or 3 judgments if I propose to rely on.
Let these things be thrashed out in the proceedings.
My lord, we observe that and dispose the interpretation that you have not entered into the merits, and the SSC is at liberty to raise all the points on merits of the matter before the AIA. The times I have seen the department says your expectations are so great interference and no, you again go to the tribunal or again you again appeal. So that should just not produce. My lord,
Writ petitioner approached this court on initiation of a proceeding under section 148 of the Income Tax Act 1961. By notice dated 30th March 2021 and 26 January 2022, Annexure 6 and 12. Stop. The objections preferred by the petitioner to the reassessment notice for the assessment year 2014-15 were rejected by order dated 20th December 2021, which is also under challenge. Petitioner was subjected to scrutiny assessment under section 143, and the assessment order was passed on 22nd June 2016 under section 143(3) of the Income Tax Act 1961, Annexure 5. 29/9/2016. Okay, then it must have been wrongly typed in our stop. The sheet anchor of the challenge that the impugn notice under section 148 of the Act dated 30th March 2021 did not fulfill the ingredients of section 147 of the Act for reopening of the assessment, as there has been no failure on the part of the assessee to disclose fully and truly all material facts necessary for his assessment for that assessment year, for the relevant assessment year. The reasons for belief incorporated in the notice under section 142(1) dated 27 September 2021 do not fulfill the requirement of section 147 of the Act for the assessment officer to assume jurisdiction and proceed against him. Stop. Respondents have filed a counter affidavit pursuant to the order dated 16 February 2022. Defending the reopening of the scrutiny assessment on a specific ground that one Subhas Kumar Modi has, during inquiry, informed the department that he had never given any money to the petitioner. Stop. Petitioner had, during scrutiny assessment, placed before the assessing officer that the entry of rupees 55 lakhs as cash in his account was received from Mr. Subhas Kumar Modi. Then counsel for the petitioner submits that if the petitioner had truly and fully disclosed the very material facts with supporting documents on which this scrutiny assessment order was passed, the department was not entitled to rely upon the same entries for reopening of the assessment proceeding under section 148, read with section 143(1) of the IT Act, and that too on the basis of intelligence inputs. That is what it is.
Information from investigation.
Information from investigation. The questions, therefore, the respondents cannot add or subtract the reasons which form the basis for belief in the order
rejecting the application of the petitioner, objection of the petitioner by way of a counter affidavit. However, learned counsel for the petitioner submits that if the court is not inclined to enter into the validity and correctness of the proceedings and the reasons for belief in writ jurisdiction, petitioner may be allowed to raise
Just raise all the points before the assessing officer.
all the points of law and facts before the assessing officer in the pending proceedings. We feel inclined to accede to the prayer of the petitioner, since the issue at hand involves determination on mixed questions of fact and law, which may in the ultimate outcome affect the which ultimately may affect the outcome of the assessment proceedings. Stop. Therefore, writ petition is disposed of with liberty to the petitioner to participate in the assessment proceedings and stop and take all available points of law and fact before the assessing officer, which shall be considered in accordance with law.